Hey folks, thank you all for joining in a little bit early here. This is going to be lessons and examples from 2022 breaches and fines. We have a lot that we're going to be covering today, and we also have a lot of people on this particular webinar. This is always the biggest webinar that we do for whatever reason every single year. So maybe it's like sometimes it's nice hearing about other people's misfortune, but also there's actually a lot of really good takeaways that you can kind of take from this. So we're going to be really digging into it here in just a couple of minutes. I want to give everybody a chance to get set up with audio. We have a bunch of people that are still rolling in. So first thing I'll do is I'll give a couple of housekeeping items because there's a few important things to keep in mind as we're going through the content here today. And the first is that we always get like 10 questions in every webinar asking this. All of our webinars are recorded, okay? Following the webinar today, you will actually get a link in your email from the GoToWebinar platform with a link to the recording. If you would like to request copies of the slides, you can request those as well. But all of that'll happen automatically. You will get that once the webinar is over and we're done here today, okay? Second thing is we do a lot of these webinars. So if you have an interest in either additional educational content, we have tons of content on our website and on our blog. You can check out tons of different things right on compliancygroup.com. It's all able to be accessed right through our website, even if there's a specific topic that you'd like to learn more about. And then the last thing to say is if you are coming to this webinar today with any specific HIPAA related questions, go ahead and submit those into the Q&A box to start, because I'll be looking at those as we get started here today. And then more importantly, if there's any questions that you have as we are actually going through the webinar, if there's anything that I say that is not clear that you would like me to cover again, go ahead and utilize that Q&A feature inside of the GoToWebinar. I will be going over all of the questions at the end of the webinar. Transparently, we have a ton of people on this one, so I may or may not be able to get to all of the questions that we have at the end. If I'm not able to answer a question that you asked, somebody on our team will reach out to you when we're done here, and we will do our best to get that question answered. Okay, so don't be worried about that. Without further ado, looks like we have a lot of people still coming in. That was just a couple of quick housekeeping items, but many of you may or may not know anything about our company, so I would like to just give a quick introduction to Compliancy Group so you have a little bit of a background on who we are. Compliancy Group, we've been around for about 17 years, and our whole business is built around the idea of simplifying compliance so that our clients can confidently grow their business, okay? In most cases, regardless of the role that you're in, even if compliance is your full-time occupation, right? A lot of the times, compliance specifically is often interpreted as like a hurdle that you need to get over or something that you need to check off of a box, right? And that you would rather not be thinking about potentially. And our goal is to just, through our services, through our software, we try to make HIPAA, OSHA, and general compliance as simple as we're able to, and also be affordable. So our mission is to simplify, but our vision is to really be the affordable industry standard for simplified compliance across the country. And our business is built on values that we use internally that we think are extremely important, both with the way that we interact with each other within our own company and the way that we try to service our clients, whether that's being accountable, whether that's having a gritty mentality and getting things done, executing when it needs to be, but also having honesty, integrity, and being focused. All things super important to us, and it's served us really well. Okay, so our software and our methodology that we have developed in roughly 17 years of doing business, we have well over 500,000 users of our software. We are in all 50 states, 40 different countries. We are endorsed by over 50 different medical associations, because we've never had a client fail an audit in the history of our company, okay? And I say that not to like give ourselves a pat on the back here, but to say that the things that we're going to be talking about today, the principles that we'll hopefully be shedding some light on as we look through these past breaches and fines, they're principles that have been proven to work, okay? And not just work a couple of times, like in legitimately thousands of organizations that have utilized our services and methodology, and all of these different organizations that endorse us and trust us, okay? The things that we're talking about today, we hope gives you some good knowledge and wisdom that you can bring back to your own organizations and begin implementing this so that you can protect yourself more effectively and hopefully have a much easier time managing the HIPAA compliance program within your organization, okay? Now, interestingly enough, we're going to be getting deep into some of these fines as we go through. Obviously, we can't look through every single settlement that happened in 2022, so we are going to kind of skim the surface, so to speak, and pull out some of the key takeaways and most important things that you can apply into your specific organization this year. But I want to set the tone and talk about some really foundational components as far as just generally, what is a HIPAA compliance program or an effective compliance program for HIPAA? What do you typically need to be doing for HIPAA compliance each year is what we're going to talk about to begin with. And before we dig into that, I want to just ask two questions. And this kind of helps me get familiar with just who we have on here today. So I'm going to be launching a poll quickly just to see, what type of organization do we have on the webinar today? And it's loading, forgive me, I'm having a little bit of a slowdown here. Okay, so what type of organization are you? Are you a covered entity in the healthcare space? Are you a business associate? Okay, you might not know what either of those things are, in which case you could just answer that third option, right? Yeah, usually the way that you could think of it is under HIPAA, there are really only two buckets that you can fall in, right? You can either be a covered entity, meaning you are treating patients, you are billing insurance for those services that you are providing, or you might be a vendor that is servicing healthcare or covered entity clients. There's also something called a hybrid entity, which means that you might have just certain portions of your business that are functioning as a covered entity or a business associate. But it looks like roughly 81% of the people that we have on the webinar today are in that covered entity category, smaller percentages on the business associate side. So I will do my best to gear this a little bit to both, but it looks like the majority of you are covered entities, and so that's who I'll try to make this more focused on. First thing worth talking about is, what do you actually need in order to say that you are HIPAA compliant, okay? And very foundationally, the highest level requirement of HIPAA is that you have what's called an effective compliance program, okay? And an effective compliance program for HIPAA, there's a lot of misunderstandings around this. People think that, is this my IT systems? Is this employee training? Is it this? Is it that? And it's really a combination of things, okay? An effective compliance program for HIPAA, this document specifically that you see here comes directly from the Department of Health and Human Services. It's essentially a very specific set of annual and ongoing standards and requirements that have to be implemented and clearly documented within your practice, organization, or business, okay? Where a lot of people go sideways, okay, and one of the most important things you can point out about an effective compliance program, without even getting into the nitty-gritty requirements here, the most important word to highlight is just that word effective, okay? The law itself is written in a way that's almost intentionally vague because of how broad these requirements can apply, right? HIPAA applies exactly the same if you are a large hospital group or a small solo practice. It applies if you are a startup software company or if you are Amazon, Microsoft, and Google, and anybody else in between, right? There's no, the law does not differentiate. It is the same exact requirements that apply across the board. But what the government's expectation is not just that you're checking these things off of a box and saying that you did it, but rather that you are understanding what can be kind of broad guidelines and implementing them into your company or organization in a way that is effective for you. Obviously, if you are on here as a very small practice, what is effective for you is not going to be the same as a large medical center or a hospital group or really anybody else. It's kind of a uniquely individual thing. So how do you actually figure out what's effective for you, okay? probably the most foundational expectation of HIPAA that was implemented is that you, on an annual basis, whether you are a covered entity or a business associate, are required to do an annual risk analysis. Okay, and the risk analysis requirement of HIPAA is essentially a series of self-audits where you actually conduct an audit of yourself, whether that be your IT systems, your physical site, your policies, your procedures, your operations, your training program. There are several audits that kind of contribute towards this. And through completing those audits, you then document the insights you received from it. So where were your gaps, right? What were the risks that you identified? How are you addressing those risks, right? Which is gap identification and remediation that you see here. Usually, there is a percentage of those issues that are found that are addressed through things like IT and security, but a lot of what you wind up needing for your HIPAA compliance program is in the form of very clear policies, procedures, trainings, making sure that you are keeping track of those policies, procedures, and training, that your employees are attesting to them or completing those trainings each year, that if you have third parties, that you have signed business associate agreements, that you are making sure that those vendors themselves are compliant, that you have clear processes for handling an incident should it occur. Lots of different layers here, but the linchpin is always going to be that annual risk analysis, okay? Because if you're doing that risk analysis and doing it properly, you'll know what needs to be done across all of these other different areas to be able to adequately and competently approach it, okay? So if nothing else that we say here in the webinar today you feel is relevant for you, just to take that, because that is a requirement that applies to everybody. And by doing that risk analysis, it kind of sets the foundation for your compliance program and gives you a place to begin, okay? So if you don't know how you're doing that in 2023, start looking into that now. You can reach out to us. That's something that our software does in a pretty automated fashion. So feel free to contact us about that. But now that we've kind of set the tone, let's look at where organizations seem to be getting these things wrong, okay? And we're gonna jump right into some of the fines. And usually when you look at the causes of a HIPAA audit, okay, it could be a lot of different things. Could be their vendors, it could be a random audit, which is kind of rare. Could be that they're billing Medicare and there was some sort of a Medicare audit or investigation that took place through the CMS. These last two things, number 4 and 5 here, are the number one way that you will get onto the OCR's radar for a HIPAA audit or investigation, and that is patient or employee complaints, okay? The majority of all of the fines that we're going to be looking at today were as a direct result of a patient filing a complaint with Health and Human Services. The OCR then investigates those complaints. They are required to, ultimately resulting in a fine, but also issues related to breaches. Okay, so often when a breach occurs, if it is not reported properly, that can easily get you onto the OCR's radar, things of that nature, causing all sorts of a slew of issues. But there's lots of ways that you could be audited, right? Now, generally speaking, the number one way that practices are being fined as of today is something called right of access, okay? And the Right of Access initiative was an enforcement initiative introduced by the Office for Civil Rights that was really enforcing components of the privacy rule having to do with a patient's right to access their own information. Okay, right of access, patient's right to access their information. Pretty simple, okay? And essentially what's been happening is in a lot of organizations, there was a practice that has taken place called information blocking. Okay, and information blocking could be something that you are actually currently doing. You just don't even know it, okay? And realistically, what is information blocking? Information blocking is any attempt or any circumstance in which a patient is requesting access to their records and that access is not being granted or they are being prevented from gaining access to those records, okay? It is the number one way that organizations are being fined as it stands today, both in 2021 as well as 2022, more fines than any other year in the history of HIPAA compliance, exclusively because of the Right of Access initiative. Now, you have an example like the Memorial Hermann Health System, okay? And it's actually interesting. They are a nonprofit, Okay, Memorial Hermann Health System is a nonprofit, and unfortunately, when you look at a lot of the data concerning HIPAA compliance, it is often the nonprofit or not-for-profit organizations that that can often have HIPAA issues, and that is not because of anybody not doing what they're supposed to. It's purely just sometimes due to lack of resources, okay? And you'll see the government is not usually lenient. So in the case of Memorial Hermann Health System, this is actually the second time that they have been fined. And this time it was a $240,000 fine just due to one patient who filed a complaint against them for not being given access to their health records in a timely manner, okay? And part of this comes from the fact that a lot of these organizations don't have a full-time compliance officer. They don't have somebody whose exclusive responsibility is managing this, and that can lead to a whole slew of issues. We'll talk later as well about cyber risk and why small practices, nonprofits tend to be at a higher risk for a breach or a fine. We'll talk about that in a little bit. But in this first case, $240,000 fine because of one patient complaint, okay? Number two, ACM podiatry. This is another interesting one because it was a very small practice, okay? And usually the very small practices get away with a smaller fine. In this case, it was $100,000, so a sizable monetary settlement. Same thing, due to HIPAA right of access failure. Now, the reason why in this particular case with ACM podiatry, the reason why the fine was so high is because they were actually not responsive to the OCR's reach out. So there was a patient complaint filed against them, and usually in good faith, the OCR will provide, if it's like a first offense, the OCR will provide what they call technical assistance, meaning they will reach out to the practice and say, hey, we received this complaint. We would like to resolve this with you. Can you please make sure that this patient receives your information and send us clear documentation showing that this was handled, okay? In this case, this particular practice did not respond to any of those inquiries whatsoever, okay? Even after second and third attempts of the OCR to get in touch with them, this led to a $100,000 fine. Again, right of access is no joke. Okay, and you'll see some of the, when you see some of the statements from the OCR director, this is really something that they're taking seriously, and it's majority of the time small practices that are receiving these fines, which we'll talk more about it later. Okay, 3 more fines due to, yes, right of access, but also a few other things. So Southwest Surgical Associates, which is in the middle, as well as Dr. Broccoli, solo practice, both same things, $65,000 fine and a $30,000 fine, simply because they didn't provide a patient with access to their records. Okay, this is, you're gonna get tired of hearing me say this. There's just so many of these fines that we can't ignore it. You have to, in your practice, have a very clear process and a very clearly documented policy and a very clear log, okay, for when patients request their information, okay? It is the only way that you can prevent these types of issues from happening is if you start now by implementing processes that address this issue and help you stay ahead of that curve, okay? Now, in the case of a company, Jacob and Associates, an interesting thing is this fine, super small practice, okay? $28,000 fine, right of access issue. But the other thing that got them in trouble was not only that they didn't reply to the to that patient's request for their records. The main, another big issue that was found is that they didn't have privacy policies that were up to date, period, okay? And unfortunately, in a lot of practices, what sometimes happens is you have some sort of like a handbook or a policy manual that has sat in the back of somebody's office. Employees aren't reviewing it every year. It's not being updated in accordance with new changes in the law or reviewed annually as is required. And so even in the case like this, where OCR might have given them a chance, right? They might have reached out to try and resolve the issue. It was found that they had been negligent in a lot of other areas, specifically concerning their policies. And what the OCR director, which is Lisa Pino, she said, it should not take a federal investigation before a covered entity provides patients or their personal representatives with access to their medical records, okay? Yeah, you have to respect the patient's right to their own information, and that's it, okay? We have a few other ones here that go a little bit deeper, and once we finish up with these, we're gonna start to unpack, let's say, some really key takeaways and lessons that you can take back and start applying within your practices today, if you want to, okay? First is Northcutt Dental. This is another very small practice, and what happened in their case is it was not a right of access fine. They were actually engaging in marketing activities where they were disclosing patient information to a vendor inappropriately, okay? We don't have the details of specifically who they were giving access to that information for. We'll talk about some trends with them on the marketing side at the end of the webinar. But not only were they disclosing patient information inappropriately to potentially a marketing company or another third party, but they didn't have a notice of privacy practice that was HIPAA compliant, publicly posted in their practice, and they didn't have anybody in the practice that was designated as the HIPAA privacy or compliance officer, okay? There's a couple of takeaways there, but first thing, it is a requirement of the law that somebody within your practice or organization, if you are a covered entity or business associate, has to have in their job description compliance officer, okay? There has to be one person that is responsible for this. If you are a small practice, sometimes that could be multiple people, like a security, privacy, and compliance officer in a much larger organization, okay? If that's not happening, that's potential for a HIPAA fine right off the bat, because that's one of the most foundational requirements of the law, is that you have somebody in place who is actually responsible for this, addressing it, that has that designation of compliance or privacy officer within the practice, okay? So we'll circle back on the marketing side of that one towards the end. You then have New England Dermatology and Laser Center. And this was an interesting one because they had a breach, okay? And the breach was because they were disposing of PHI, like literally just taking patient records and throwing them in the garbage instead of shredding them or another ethical means of disposal when it concerns patient information. In the investigation of the OCR, they weren't fined for the issues relating to that disposal, okay? That can get you investigated. They were fined because they were found to not have done a risk analysis, which is that really foundational component that we talked about to begin with. And that failure to do their risk analysis resulted in them never implementing the necessary safeguards that would have been required for them to have within their practice, okay? So you have a bunch of issues here, but again, it goes back to the same exact root cause of not doing their risk analysis at each year. And so what I would just highlight for you is, number one, there's really a couple of things here, but first thing that I'll say is that the government doesn't have very specific requirements around how PHI needs to be disposed of, okay? What matters is that however you are disposing of it, is that it is through a method that is private and secure, and that you are documenting that as part of your risk assessment, that that disposal is taking place in a way that is compliant and secure, okay? The other thing is making sure that you're actually doing that risk analysis every year. It's another thing. You will probably get tired of hearing me say that, but it's probably the most foundational and important point of your compliance program, period. Third one for this slide, Oklahoma State University Center for Health Centers, okay? As you can see, there's a lot of problems here, okay? There was ultimately a breach resulting in the impermissible disclosure of almost 300,000 individuals. So this is no joke. This is a massive breach, huge issue. But the interesting thing is, again, most organizations that have a breach don't get fined for the breach in of itself, right? A breach can lead to you being audited. But the only way that you get fined is if the government audits you and finds that you were non-compliant in some aspect of an effective compliance program, meaning you weren't abiding by the right of access policies, You didn't do a risk assessment. You didn't train your staff. And in this case, it was a whole slew of issues going on. They hadn't done their risk analysis, okay, which is the main issue here. And so their incident response and reporting was not set up the way that it needed to be. They did not evaluate the breach after it occurred. They did not implement audit controls, which is something that would have been done as a result of that risk analysis being completed. And ultimately, they didn't even report this breach. Okay, I believe it was ultimately investigated by the FBI, who turned it over to the OCR, resulting in them being fined. Okay, so a couple of takeaways here, but what caused the majority of breaches in 2022? And the interesting thing, when you look at the overwhelming majority of breaches in most cases were with healthcare providers, okay? And it's typically hacking / IT incidences. And that can be kind of deceptive when I first say that, okay? Because when you say hacking / IT incidents, what you might be thinking of is like a cyber predator sitting in their computer, hacking into your systems like they do in the movies. And that's not really how it works in real life most of the time, okay? Most hacking and IT incidences occur, yes, there are cyber predators trying to get into your systems, but what usually occurs is some form of human error, okay? And so what do I mean by that? Meaning 86% of the time, it's not that the technology failed. 86% of the time, it's that a person failed, meaning they clicked on a link in an email that they weren't supposed to, which subjected you to a ransomware or a malware attack. They were on a website clicking links that they maybe shouldn't have been clicking on, ultimately compromising your systems, right? Those are the types of IT incidences that ultimately cause the most issues, and it's currently the greatest threat, right? So, because if you're not doing a risk assessment, these things can be occurring for a very long period of time, where if somebody gets access to your database and your system, they can be roaming around in there as long as they want to. But the other issue is a lot of people kind of neglect that human component, right? You might be on this webinar and you have very, very advanced security protocols and IT protocols set up within your organization, but it's all on the technology side, right? And most of the time, you can be highly secure, but not in any way HIPAA compliant, right? Security is really about mitigating your risk of a breach, where compliance is your ability to show and have clear proof that you satisfy the requirements of the law. And this is really where you're going to cover those human error sides of things, making sure that your employees are being trained, making sure that you have very clear policies, procedures, which will not only being secure reduces your risk, being compliant prevents you from being fined. Those two things coming together really is what kind of formulates an ultimate risk mitigation strategy, right? Giving you really true safety as an organization. But if both things aren't happening, it's a problem, right? Now, how do you protect yourself from HIPAA right of access fines? We've talked about this a little bit, but gonna kind of drill home some of these points here for anybody listening. First thing is, you absolutely have to respect an individual's right to access and receive their own medical records. Any attempt whatsoever to prevent a patient from getting access to their medical records is not allowable under HIPAA, period, okay? You have to abide by these requirements. Now, number two with that is you have to provide the records in a timely manner. And so if you're wondering, like, what is the time frame, what is considered to be a timely manner, usually within 30 days is the expectation. And if you are not able to meet that deadline for whatever reason, clearly request and document an extension, okay? So that you have that documentation should the OCR investigate or that patient file a complaint. Now, the other aspect of that is it should be easy for a patient to get those records from you, meaning there shouldn't be 10 hoops that they need to jump through before actually being able to get access to their records. Maybe on your website, you set up a portal where you can have patients submit those types of requests. If there are fees associated with that, which is on I believe on a case-by-case basis, depending on the state that you're in, make sure that it is easy for them to request and pay for their records, okay? Set up a system, even if you don't have an electronic means of doing this, set up a system within your practice so that if somebody calls in or sends an email, you keep a log of all of those people who are requesting and have a clear process that you follow to get them that information in a timely manner, okay? Very, very important. So now we're gonna really dig into some lessons, okay? We talked a lot about right of access, but, and that's really the bulk of the fines that we saw today. But one of the most important takeaways here in lesson number 1 is that all organizations are at risk of being investigated for a HIPAA violation. So it used to be, even if you went back just like 4 or 5 years ago, you didn't see small practices being audited that often, okay? Now, more than 65% of all of the settlements in 2022 were to very smaller solo practices. That's not anything that we've ever seen before prior to these last 2 or 3 years, okay? So if you are a small practice, right now in the OCR's mind, because it seems to be small practices that have these issues most often, you are in many ways the primary target of the OCR, okay? So you wanna be thinking about making sure that you have these requirements set up in a way that is sufficient for your needs. If you don't, start implementing that now. It's the beginning of 2023. It's a great time to be looking into some of this stuff. Second thing is, if you get on the OCR's radar for any reason at all whatsoever, make sure you are cooperative and extremely responsive to those requests. Don't let them sit, reach out right away. Okay, oftentimes you'll have an auditor that you can even email back and forth with. Is having that level of cooperation and clear transparency in your communication with the OCR is a great, even if you get fined, that could be the difference between a $23,000 fine and the $100,000 fine that we see levied against ACPM podiatry, sorry. So very important. Third thing is keep a clear log that tracks access requests. And by doing that, what it really shows is that, let's say in the event that you get audited, it shows that you are taking those obligations seriously, that you have a log, a process, a policy, and a procedure associated with right of access requests. That goes a long way in preventing these types of fines from occurring. But the other thing is keep in mind that a patient can only be charged a reasonable cost-based fee when requesting their own records for their own use. And so what does that mean? Basically, if a patient is trying to have their records sent to another practice so that they have a new place of treatment, they can't be charged for that. Okay, so depending on your protocols, it's another thing that you want to make sure is clearly written into your policies. And then number 5, all organizations need an effective compliance program, okay? Because what does all of this come down to, right? The only way that you get fined as a practice or organization is if you don't have clear documentation of good faith effort, okay? Meaning you don't have clear proof that you did your best to reply to a patient's request for their records, okay? You don't have clear proof that you completed a risk analysis and identified potential deficiencies. You don't have clear proof that you have up-to-date policies, so that you trained your employees, so that you vetted your vendors this year, right? All of those different aspects, and the linchpin, of course, is going to be that annual risk analysis. That is the most important thing that you could be doing within your practice today to get ahead of these things. And even right of access stuff is all lumped in with that. Okay, so in most cases, you can really mitigate a lot of your risk just by doing a full and effective risk analysis each year and then addressing the gaps that you find. Okay, now we're going to talk about some predictions. Okay, and then we'll go to Q&As. In 2023, it's looking like we're going to continue seeing issues related to right of access. So even just from 2019 to 2020, there was a 450% increase in right of access fines. There were more fines then in 2021. more in 2022. It's looking like we are going to continue seeing that, and it's looking like it's going to continue being the focus that those fines are going to be given to smaller practices. We've already seen settlements this year in 2023 levied to very small practices, okay, that had right of access issues. So that's going to continue probably being the focus of the OCR, we think, for quite some time. It's a great thing to start looking at and focusing in on within your practice, okay? Another thing that's good to talk about is kind of the implications of the Dobbs decision, okay? And the reason why it's worth discussing, and you can read the blurb here, in the wake of the Dobbs decision, Health and Human Services will be putting more emphasis on responding to patient complaints that allege that providers have improperly used a patient's PHI without authorization, okay? And what that really means is specifically what was occurring is in the wake of, let's say, Roe v. Wade and the Dobbs decision overturning it, a lot of the right of access issues that were occurring were about patients that were receiving abortions that were requesting their information, okay? And then state or federal law investigating those providers, and those providers not providing those records to the state or federal governments, okay? What the Dobbs decision essentially stated is that if a state or federal government entity is requesting you to send your patient's information to them as part of an investigation, you have to do it, okay? And that doesn't just apply to things concerning the issues related to abortion. This is any type of a state or federal investigation where they are requesting you to send patient records in their entirety. You have to comply with that. And that's something that is coming now in the wake of the Dobbs decision. So just keep that in mind. And then the last thing, and this is actually a really important one. We are going to be doing a webinar in the future specifically on the topic of HIPAA compliant marketing. But there's a lot of issues that have been coming up in this past year concerning specifically healthcare marketing and the ways that you are allowed to use your patient's data to market your services either to your patients or to a broader base, okay? So there's something called, and this is not something that many of you will be familiar with, but obviously, Facebook or now Meta, they have something called Facebook Pixel, which is essentially their online tracking tool for marketing purposes. And what a business can do is it can take their clientele, upload it into the Facebook Pixel, and create a lookalike audience that allows them to not only market to those specific patients, but market to people that look like those patients, right? And the issue is that by doing that, they are hugely violating their patient's information because Facebook does not sign a business associate agreement. Facebook is not a compliant platform, and really no social media platform is going to be compliant in that regard, okay? So one of the ways that this came up is with that practice we were talking about earlier with impermissible disclosures for marketing purposes. This is the issue that was kind of occurring, okay? So number one, if you are like a self-made marketer and you are marketing your practice on your own, double check your processes for how you are utilizing your patient's information in the process of marketing, right? Make sure that any of the platforms that you're using for marketing purposes are HIPAA compliant, that you're signing a business associate agreement, that all of that is being set up properly. But also, if you are outsourcing this to a marketing company, okay, double check with them to find out how they are marketing your services, right? Are they marketing it on Facebook? That could be okay, but are the marketing programs that they're running through Facebook, are they using patient data to do that, right? Because that's not allowed. So some of those things really good to start digging into. We see this being a much bigger issue that's going to be blowing up into 2023 due to a bunch of organizations that got in trouble for issues related to marketing in the Facebook Pixel. Okay. Last thing I'll say is if you need help, or maybe you don't need help, maybe you are an extremely competent and experienced compliance officer, but you would like to be able to address these requirements in a way that is much more automated, much easier to document and maintain, we would love to speak with you. So again, our software truly is designed to simplify and automate many aspects of this process so that you can quickly complete the risk analysis of HIPAA, then automatically generate policies, procedures, and training, distribute those, document everything. Our program is all inclusive. It's a flat annual subscription. If you'd like to learn more when you exit out of the webinar today, you'll have the opportunity to request information. If you do so, somebody on our team will reach out to you just to see what you're looking for and provide you with a quote. We try to, again, be as affordable as we can. So if you'd like more information, don't hesitate to reach out. With that said, that concludes the content of the webinar today. I'm seeing we have had a ton of questions rolling in, so I'll take some time here and kind of just go through those questions one by one. Let me see if it'll let me pop this out. Okay, so first question was, will slides be sent out? So a recording and a transcript will automatically be sent out through the GoToWebinar platform. If you would specifically like to have access to the slides, you can go ahead and send an email to info@compliancygroup.com. Let them know that you would like to have access to the slides, and also please give us some feedback on the webinar today. You could either say, hey, Liam did an amazing job, which is what I hope you say, or you could say, I think that this content could be made a little bit better if you focus on this, or if you expounded more on this. We love that type of feedback. So please, that's info@compliancygroup.com if you would like to get access to the slides. So question came through, is it considered a breach to disclose SUD records to a third-party payer for risk adjustment review purposes? Okay, so the good thing is that covered entity to covered entity interactions are never considered a violation. Okay, so if you're working with a health plan and you're doing risk adjustment review, perfectly acceptable to be sharing patient records because they more than likely will have access to them anyway. Okay. How much can organizations charge for medical records request from MN Disability and Social Security? They have a section on their request for this information. So that's, I hesitate to give specific insights on this webinar for that because it is going to vary depending on the state that you're in. I would recommend either reviewing your local state regs, or just speak with your lawyer to find out, what is a reasonable cost-based fee to respond to requests for medical records. Another question. If one clinic exchanges emails with a practitioner and a separate medical practice, do you need to put that on the disclosures log? It depends on what the exchange is taking place for, okay? So in general, those types of disclosures are perfectly fine as long as it's for TPO, okay? Treatment, payment, operations, meaning if you are sharing it with a separate practice, it should be only shared if that practice is also potentially treating or providing services to that patient, okay? If you're just exchanging emails for like co-marketing, that absolutely could be a potential violation. You want to be careful of that. Do we need to have BAAs signed going both ways? So we ask the BAA to sign our agreement and then we should sign one from them. Is one BAA not good enough? So as a concern to your vendors, or if you're a BA with covered entity clients, you only need one BAA, okay? So you don't need to have like one from you to them and one from them to you. Just a single BAA will usually cover you. Whether you sign theirs or they sign yours, that's really up to you, however you want to decide how to approach that, but you only need one. Another question. Do fines go to the patient that had issues with their data or stay with OCR to spend as they see fit? So the fines do not go to the patients, although there is something that's occurring in which a patient can actually directly sue a practice to receive compensation. But right now, those fines stay directly with the OCR, so not going to the patients. Yeah. Just looking through some of these questions here, folks. Okay, so Angela, there was a question that you submitted. and I'm not sure I'm understanding the question. If you like, please feel free to email me. My email is up there on the screen. Would be happy to chat with you about this specific question just to make sure I'm understanding it properly. Okay. All right, another question. And folks, I do apologize. We probably will not be able to get to all of the questions. There's going to be, we have a lot of people on here and a lot of questions coming in. So if we don't get to your question, we will do our best to make sure we get with you after the webinar is over, okay? I just received a request for medical records from an inmate. I had to request a HIPAA authorization form via mail, which is frowned upon because of the time it takes. Do you have any input upon this scenario? So if that is the process that you have set up, it's not ideal, but really there's no getting around it, right? If that's the process that you have to follow. Ideally, there would be some means of doing that electronically, but if that's not set up, doing it by mail is fine. But again, you want to have it clearly documented that this is our process, this is the approach that we take, and make sure that you keep a log. Okay, so how do you reconcile right of access with the Cures Act information blocking exemptions? If I'm understanding this question correctly, okay. So the 21st Century Cures Act had a lot to say as well about, first, interoperability, meaning it should be easy for a patient to get access to their records, is basically the whole concept of interoperability between an EHR and the provider and the patient. And it prohibited as well information blocking, okay? The 21st Century Cures Act has a few exemptions of that. I'm not going to get too deep into the weeds on this, but it's the same exemptions actually that are under the privacy rule, okay? And specifically having to do with a mental or behavioral health practitioner's therapy notes, okay? If you are in the behavioral or mental health space, there are certain aspects of your records that are protected that you do not need to provide to a patient if they ask them. That would specifically be your therapy notes, right? So notes that you take in the process of speaking to and treating those patients are actually still can be kept private between yourself within the practice, okay? Sorry, folks, just going through some of the questions here. So what kinds of things need to be documented? Anytime documentation is sent out, for example, we get a records request with an accompanying consent. We respond to that. Does that need to go in the log? Usually it's not, it's a good idea to keep a log of all of those requests. The consent forms as well help. But having just a general access log is a great way so that in the event that you get audited, you have very crystal clear documentation showing that we do this every single time we get a request for records. And it doesn't have to be that complicated, just like a name, time, who it was sent to, so on and so forth. When a request has been received for the entire record, does this include psychotherapy notes? So again, no, that is, and as a follow-up question, as a therapist, what is the best way to block access to records that might prove harmful to client? So therapy notes have a very specific exclusion under the privacy rule as well as the 21st Century Cures Act. So you do not need to be worried about that aspect of it. In the event that you have a patient giving you an issue, obviously you'd want to consult a lawyer or get some advice on how to handle that. But you have specific exemptions, and the laws in your favor in that regard. So another question, I know every facility's SRA is going to be different, but do you have any resources on what should be included in the SRA? Yeah, so usually a security risk analysis has to touch on 3 different areas, okay? Technical, physical, and administrative requirements. Technical meaning your IT, Okay, so like general IT, your network, as well as your devices. So those are kind of the two audits that usually need to be included in that IT component or the technical side. There is then a physical site audit, and then you need to do an administrative assessment. And what that means is you need to make sure that you are reviewing your privacy policies, your security policies, as well as your breach notification policies, procedures, and training, okay? So that's kind of like 6 audits, if you want to think of it that way. That's how we break it down with our clients. What's most important is that for each of those aspects, that in your assessment, you are clearly citing the regulations, clearly documenting the gaps that are found, and clearly documenting how you are addressing those gaps. That can be somewhat labor intensive depending on how you approach it, but doing it once and getting that taken care of, even though it can be a very heavy lift, it's a fantastic way to mitigate your risk. I'm just checking through a few other questions. We've got some duplicates here, folks. So I'm just looking for one more good one before we close out the webinar today. All right, so question regarding social media. What happens when an employee friends a patient on Facebook? Is that a HIPAA compliance breach? So general recommendation is that within your practice, you really ought to have a social media policy in place. And what the general recommendation is obviously you can't prevent a friend of an employee from going to the practice, but it is maybe I would be cautious of employees reaching out themselves to patients on social media platforms, okay? If a friend requests you, if you have a Facebook page and patients want to interact with you there, that is completely fine because that's on them, right? They are deciding to be the ones that are disclosing their data online. What you can't be doing is like, if you have a practice Facebook page, you can't be replying to their posts and confirming all sorts of data, disclosing information. That is something you want to be extremely cautious of, okay? Practices have even been fined for replying to Yelp reviews and including information in their reply that should not have been included. So you want to be really careful of that. Does annual risk review mean once a year as determined by the organization, or does it have to be done at a specific time, like the end of the year? This is a really good question. And so the best way to answer it is that under HIPAA, they don't require, let's say, that the risk analysis be done annually. They require that it be done ongoing, okay? And ongoing can mean a ton of different things. Really, it's left up to your interpretation, when in the year you want to do it, how you want to do it. But the general rule of thumb as a best practice is that you should be doing a risk assessment once per year and then keeping it up to date throughout the year. Okay, that's kind of general best practice. The law really just states ongoing, and that could mean really anything. Okay, so like think of it as like a minimum standard, do it once a year and then maintain that information throughout the year. And I think we have time maybe for 1 or 2 more. So a question, do you have webinars that are more specific to general IT controls for HIPAA compliance? It's a good question. I would actually be cautious with this question in your line of thinking, okay? And the reason I say this is because HIPAA doesn't have very specific IT controls or safeguards that are required, okay? The regulation does not even ever mention encryption, okay? What the law states is that you're gonna get tired of hearing me say this again, you probably already are, but you have to do a risk analysis. You have to identify your risks. And then you need to make a good faith effort and clearly document how you addressed those risks. So if you are conducting an assessment of your IT systems and you find that there is a deficiency, there really could be a million different ways that you could address that deficiency. What matters is that it's clearly documented and that it addresses the risk that's found in the assessment. That's going to be very different depending on who you are. okay? So my ultimate recommendation is just to actually do your HIPAA risk analysis. That will give you the insights that you need on where your risks are from an IT perspective, so that you can then begin implementing those controls. For annual risk analysis, does this have to be submitted somewhere or just kept on record at our facility? It does not need to be submitted. It just has to be clearly documented and kept on record at your facility, okay? In the event that the OCR was to audit you, they have the right to ask for copies of your risk analysis records from up to 6 years ago, okay? Just be prepared for that. Again, in the topic of good faith effort, if you haven't done that in the past years, get it done now, okay? Because that's gonna show good faith effort and just make sure that you're where you need to be. So with a business associate agreement, if your vendor has you sign one, should you keep a copy for your record, since you said that one should be enough? Absolutely, yes. So even if you are signing a vendor's BAA, you absolutely need to keep it on file, because in the event that that vendor has a breach or an issue, the BAA is the only thing that will actually protect you, okay? So make sure that you keep it on file. That should be clearly tracked in a folder very specifically for business associate agreements. And then one more question. This is a good one because it kind of covers a broader spectrum of things. PHI and email, okay? Is Gmail HIPAA compliant? Is Outlook HIPAA compliant? And the answer out of the box is always going to be no, okay? So Gmail, Outlook, general rule of thumb is if it's free, it's not HIPAA compliant, okay? So Gmail, Microsoft, Outlook, out of the box, it's not gonna be HIPAA compliant. In order for you to set up your email in a way that is HIPAA compliant, you need to upgrade to the paid business version of that service with a BAA. So for Gmail, you need to upgrade to Google Workspace and sign Google's BAA in order for it to even potentially be HIPAA compliant. And then you need to make sure that those emails are being encrypted. And email encryption services are really pretty cheap. There's a bunch that do it automatically and it integrates right into your Gmail or Outlook account. The company that we recommend for email encryption is typically Luxi. That's Luxsci. If you want to request information from them, let them know that Compliancy Group sent you. They are a fantastic company. It's affordable. It's really the best way to do that if you're looking to encrypt your emails going in and out. So that's what we recommend. And folks, there's a lot of questions here, and I again apologize I was not able to get to all of them, but we are just about at our time. Thank you all so much for attending the webinar today. I am positive that an hour-long webinar about HIPAA compliance was not the bright shining star at the top of your day, okay? But hopefully you got something out of this and you have some good takeaways that you could bring back to your practice. And again, if you would like more information on our software and how it could help you, when you close out the webinar today, feel free to request some information, and you can also email info@compliancegroup.com if you have any feedback or would like the slides. If you want, email me, give me a call. I'd be happy to chat with you. All right. Hope you all have a wonderful day. Thank you again for jumping in here.